Time is limited, but your success doesn't have to be. At LawPay, we are committed to helping you succeed while making the most of your valuable time. Try our simple, secure online payment solution today, and you'll pay no monthly fee for a whole year. Learn more at lawpay.com/dcbar.
Good morning and welcome to Brief Encounters. Thank you for joining us for today's podcast entitled Lawyer as Counselor. I am Margeaux Thomas and I'm here with Christine Bacon. We're both attorneys who practice with the Thomas Law Office. Christine is a business litigator handling complex issues for sophisticated clients in federal and state courts, and her practice has included matters such as commercial law, real estate, creditors' rights, banking, construction, contracts. And in addition, she has published numerous legal articles for Thomas Rutgers Westlaw in the areas of First Amendment speech protection, international and intellectual property law, and various federal statutes involving business matters. I am also a business litigator and have represented individuals and small businesses in complex commercial and real estate litigation and class action cases at the trial and appellate level throughout Virginia, Maryland, and the District of Columbia. My primary area of focus is commercial landlord-tenant disputes, business partnership disputes, and contract disputes, including franchise, partner, shareholder, non-compete, and non-solicitation issues. So I will hand it over to Christine to give us an introduction on our topic today, Lawyer as Counselor.
Good morning, everyone. So today we're going to be talking about this concept of lawyer as counselor. And so I thought maybe we could start out by just interrogating that for a second. Sometimes people use lawyer, counselor, attorney to mean the same thing, right? And they can, but they don't always. So especially in litigation, sometimes there's a lot of anxiety, there's a lot of hand-holding with our clients. And so, I just wanted to explore that. Margeaux, when you say lawyer as counselor, what is it that you mean by that?
Yes, I think because I primarily do litigation, all I do is litigation. The counselor role or hat that we put on is at the forefront of most of our cases because litigation usually involves a lot of anxiety. It's an adversarial process. It's usually a long process. It's stressful. It's unpredictable. It can be very expensive. So when all those things converge, I think as our role in lawyers involves us having to put on a hat, not just to represent our clients in court, but also to counsel them through the process, which involves explaining to them, the pros and cons and what effect that may have on their lives going forward. I find that with a lot of my clients, there are a number of factors or people or situations that play a part in their decision-making, and they may not be readily apparent at the beginning of the litigation or when meeting that client. And I think it's important as our role as counselor to understand, what those things are that are weighing on their decision-making capabilities and outcomes that they're seeking to achieve, and keeping those in mind when we do talk to them about, how the process is going to go. An example of that would be, some people they care more about the principle. You hear that a lot. It's not about the money. It's not about who wins or loses. It's about the principle. I mean, if I had $1 for every time I heard a client say it's about the principle. And I think that involves digging a little bit deeper and understanding what that principle is and whether that's something that we can address throughout the litigation.
Yeah, absolutely. I love the idea of thinking about who else is involved in your client's life that would impact their ability to make a decision, or maybe not ability to make a decision, but the reality of their decision-making process. And so even though those other individuals are not your direct client, they impact the way you're going to be handling the case, right?
They absolutely do. And I know that we're going to talk a little bit about mediation here because that's something that, is very close to my heart. I think it's a great tool. But I can say that in a more informal context of mediation, sometimes it is important to talk to those people who have an influence on the actual decision maker. And through mediation, that's one of the vehicles where we can, involve that person to some extent, which you might not be able to do just in litigation in court.
Yeah. I want to talk for a minute, and maybe mediation comes into play here. Are there particular sort of go-to techniques that you use to calm your clients down? Is mediation one of those? I mean, do you often use that as a way to, kind of ease in before you get to court, I guess, before you get to litigation, which of course we don't always get to trial. Most cases don't go to trial. But what are the ways that you use to sort of calm your clients I can share, for me, I think one of it is to let your clients know that this may be their first time in court, but it's not your first time, right? And so you sort of instill some confidence in them that it's okay. I've got this. I know the ins and outs. I know the court rules. Oftentimes, you know the players, you know the judges involved, right? And because litigation in court can feel very foreign to most people. Most people don't go to court every day. Mediation, on the other hand, we all know how to resolve disputes with our neighbor, with our kid's teacher, right? And so that can feel more familiar to clients.
I think you touch upon two really good points. One is setting the stage. Like you said, as attorneys, we sometimes take for granted the fact that we are in court all the time, and that may be a comfortable place for us to be. We know what it looks like. We know who's going to be there. We know where to sit. We a lot of times know the judges on the other side or the attorneys on the other side. So it's not a stressful situation to say I have to go to court on Friday. But for someone who is our client who isn't in court all the time, they may have no idea. They may have never been in a courtroom. So that experience of going into an unfamiliar setting alone can evoke a lot of stress and anxiety. And one of the tactics that I implore a lot to deal with that is to set the stage for the client. I talk about, what it's going to look like, how many people are going to be there, where the people are going to be sitting, where they should sit. A number one question a lot of people get in court, like, where do I go? Where do I sit at? That just those small things. If you can get those things, explain them and evoke a level of comfort having to do with just those little minute details, I think it lowers the level of anxiety when somebody has to walk into court for the first time. Another thing I talk about is where to look. Like if you're on the stage, who do you look at? Are you looking at the judge? Are you looking at the other attorney who's asking you questions? If there's a jury, are you looking at them? That's very important. What to wear, be comfortable. Don't wear your pajamas, but be comfortable. And that's something that comes up. So I try to lower the level of anxiety by just explaining, what the environment is going to be like. And sometimes when I don't know if I'm in a new courtroom, I will go there before that day so that I know what the environment looks like. So I know where to go, but also so my client, I can explain that to them so they understand the environment. The second point you brought up is mediation. And I think that mediation, no matter when it's done in the process, because I've had mediations before we filed suit, I've had mediations right after we filed suit, right before summary judgment, after summary judgment's been filed. I've even had post-trial mediations before we went up onto appeal. So no matter when those mediations take place, I think it is a really important tool because it is a much more informal environment. The client can talk to most of the mediations we do have retired judges. They can talk to the retired judge who is the mediator and they can feel heard. They can explain their side of the story. They can explain the things that they think are important, what their expectations are, how they feel wronged, whatever it is that they want to voice. They have the opportunity to do that. And in court, they may not have that floor. I mean, even if they're called to be, at the trial, the questions are very structured and, they don't get the same opportunity to tell their side of the story as they would in mediation. And I think just being able to have that platform in the informal room or over a Zoom with a retired judge greatly decreases the level of anxiety for my clients.
Yeah. Something you said kind of harkens back to where we started this conversation about lawyer as counselor and listening to your clients and thinking about, their decision making. And I think it's important to consider what their needs are and what is the outcome that they desire. It isn't always money. You had said you can't count how many times you hear it's about the principle. It's not about the money. And our clients just want to be heard. One example from my practice in that regard was we represented a gentleman who had been in a business relationship with a very dear friend of his, kind of relationship where, nothing's ever going to go wrong. And of course, things did go wrong. And so we were in court trying to force a dissolution of this close corporation. And it involved some allegations that our client wasn't a good businessman. And that, I'm sitting in meetings with him and listening, and I could tell that he was very hurt by that. That's what he focused on more than the dollar amount of the value of this corporation that we were trying to dissolve. And so, in the context of motion practice, we were able to sort of get his voice, kind of out there in the form of an affidavit that he filed. And soon after that was filed, unbeknownst to any of the attorneys, the two gentlemen met for lunch and worked out a settlement, and he walked away happy, And so in that case, he really just wanted to feel a little bit vindicated, I think, in terms of his business acumen, and put it out there in the world that he was a good business leader and he knew what he was doing. And once he was able to sort of say his piece, he was happy. So yeah, I think that can't be understated.
Yeah, I think it's a lot like therapy when you just talk about a situation and you are able to move past certain things by just voicing that concern to someone who hears you. And in that scenario, we have a lot of clients that may be stuck and can't move forward because of certain things that they're holding on to. And being able to voice that and understand what needs to be voiced and who needs to hear it can help in that process of, helping clients move through this.
What percentage of your cases would you say go through mediation? And I know you practice in several different jurisdictions. Are there different rules that apply in the different jurisdictions?
There are some jurisdictions have mandatory mediation and court mediation programs. Others don't. Like in Virginia and Fairfax, where our office is located, they don't have a mandatory mediation program in state court. A lot of people go to private mediations through groups like the McCammon Group and other retired lawyer groups. In federal court, you may have in most cases, we have magistrate judges who do the mediations, and those are usually voluntary, but normally a required step in the process, or at least we see it that way. So I would say a large majority of the cases that we handle go through some form of mediation, either some mandatory or voluntary process. And I certainly encourage it because, like I said, I think that helps with the clients, dealing with the stress of litigation. Mediation, if they're able to come to a resolution that doesn't involve a third party deciding what that resolution is, it's usually easier to deal with because it isn't a surprise. Normally, we can think out of the box and come up with creative resolutions that may not be possible if we were to go through the court process. And that can speak to some of the concerns that our clients may have that may not have been addressed had we went forward. We were talking about principle, there's not a lot of cases where we get apologies. You definitely usually are not going to get one if you go to court, but I have had a small handful of cases that went through mediation where, a party apologized to another party. And that was something that, definitely affected the client's mental state and their willingness to settle and what they were willing to settle for because, that apology meant a lot. So I would say a large majority of our cases do go through mediation, and I am a big proponent of it because I do think that it can address a lot of intangible things that may not be addressed through the court system.
Yeah, absolutely. When the client can be organically involved in the outcome as opposed to having an outcome imposed upon them, they're sort of buy-in to the solution, and I feel like they're more willing to honor that and walk away feeling that at least they got something out of it. I remember my contracts attorney in first year law school explaining alternative dispute resolution and contracts, and he used the example of the orange. People fighting about, they both want the orange, but when you dig down and you listen, you realize that one party wants the orange because they want the rind for some reason. And the other party really just wants to juice it and doesn't care two hoots about the rind, and they just want the juice. And if you litigate it, one party's going to get the orange. But if you mediate it, maybe they can both walk away with a piece of what they want. So I try to keep that in mind.
I love that analogy. I'm going to steal that. I love it. I think that directly speaks to the point of the alternatives and creative solutions that mediation can have. And I think that goes directly to the topic of, mental health and the things that people are thinking about and that cause stress. You're able to address some of those things in creative ways. So
yeah. So actually, I want to move us a little bit. Nice segue. Mental health. So we read these articles about mental health in the legal profession and stress on lawyers. I feel like our clients can pick up on our own anxiety. So if we're feeling really anxious about a case, our clients know that, right? And it only increases their anxiety. So what about, as a litigator, when you spend your day in contentious discussions, perhaps back and forth with opposing counsel, how do you manage your own stress and anxiety? And how important is that?
So I worked with an attorney who's now a federal court judge, and I was a baby attorney, and he was like, I just can't have stress at home. Like, I come here, I argue, I advocate, on behalf of my clients in very stressful environments. And my divorce was the most harmonious thing. That's what he said. His divorce was the most harmonious thing because he's like, take whatever you need. And, I can't litigate on both fronts, so I either have to do this at work or at home. I can't do it at both. And I think that's something that stuck with me for whatever reason. I feel like my home life has got to be peaceful. I am the last person to sue a vendor at my house or anything goes wrong because, I can't litigate those personal disputes and do that on behalf of my clients. At least that's the barrier I found, and I found that a lot of other litigators kind of abide by that as well. But being able to come home to a peaceful environment is very key to being able to do a stressful job to me. I think compartmentalizing is part of it, which can be difficult, but I think the longer that we practice law, the easier maybe that gets, because we're more familiar with the types of issues that our clients have and how those issues will be resolved. So it's easier not to, stay up at night thinking about those things. But, I think that it's important to get rest. I think rest is just as important as work. So being able to put those things down and leave the office and come back fresh so that we can deal with those issues is super important. I think it's kind of a disservice to constantly be doing work and be up late doing work, waking up early doing work. I mean, it just does not give you the insight that you might have if you were well rested. So I think it's important for me to turn off my phone and to not answer emails after a certain time of day. And I cannot be the 24/7 attorney, because that just isn't good for my mental health. It isn't good for my clients to have an attorney who's tired. And, I don't function well in that environment. So, I have to put up certain boundaries so that I can be at my best. I can't stay up till 2 o'clock and then wake up the next day and try a case. I mean, I know probably some people can, but I know that I can't. So I think that taking that time out to rest is super important. What about you?
Yeah, I think all of what you said speaks to me. We to some extent, I feel like the way the billable hour contributes to this stress and anxiety. The way we've structured legal practice in and of itself is stressful. I remember I had taken a break after having my first daughter, and then I was going back to a big law firm where, the billable target is pretty high. And the night before my first day at that new job, I had a dream about clocks. It wasn't very innovative or original. I literally was in a room filled with thousands of different kinds of clocks. There were year clocks and grandfather clocks and cuckoo clocks and digital clocks and alarm clocks. And I woke up the next morning thinking, geez, couldn't you think of something a little more creative? But those 0.1s, those 6-minute increments, and then what that means in terms of revenue. And of course, we all need to make a living and put food on the table, right? And so I think that is stressful. And I think it's important to also know, when you're considering what area of law to go into, for me, business litigation allows me to be able to compartmentalize a little bit better. I don't think I would be a very good family law attorney. I don't think I'd be a very good criminal law attorney, because I'm not sure that I would be able to separate myself enough to have that downtime that is so important. And obviously there are lots of attorneys who do that work and are very good at it and can handle it. So I think it's important to know yourself and what you can handle as well.
Yeah, I think that's a very important point. And I hear a lot of attorneys talk about that. I mean, I think being in the right practice area goes to your mental health a lot. I mean, there's some things that I think would keep me up at night and I wouldn't be able to let go and walk away from at the end of the day. But I feel like business litigation is a good fit for my personality type, because I'm somewhat calm to begin with, and my clients are in a very stressful situation. So I think that is a good balance. We can't both be hair on fire moments. And I tend to not have that, I bring a calm demeanor to the table, and I'm going to look at this strategically. And, I recently had a client who is a therapist and was just saying that she felt she was emotionally attached to this situation that she was dealing with her commercial landlord, and just having the ability to talk to somebody and get a objective viewpoint of, this is the way that this usually goes, and these are your options, helped her be able to, move through that process. And that is a great example, because it wasn't a court process. We were trying to negotiate an out-of-court arrangement having to do with this commercial landlord-tenant matter. And, it's just being a sounding board in that respect. And, that's what she needed for her sanity in this situation, was just to have somebody there to talk to say, yes, this is the emotional response, and this is the more objective response. And just being able to see that it is helpful to clients. And I certainly think that situation was the role of being the counselor, not the advocate. I mean, we didn't even speak with the other attorney in that case, but having our client and walking through the potential outcomes with them and saying, this is not what would normally happen, but if your mental health is worth a lot, And I think that we need to weigh, what that looks like. Are you willing to pay more money or take a less advantageous legal resolution in order to just free yourself of this situation? And in that situation, the answer was yes. And just being able to walk through those scenarios and talk about it, I think was very beneficial.
Yeah, I think sometimes as litigators, we have this idea that we need to win at all costs.
Mhm.
And that isn't always the right answer for our clients.
Yeah, I think that managing expectations is a huge part of it. And winning at all costs is not every client's goal. So I think we do our clients a disservice if we just go into every case thinking, we want to win, we want to get them the most money, we want a verdict that goes their way, because a lot of times that may not be what a win looks like. So that's one of the first questions we ask on every intake call. What does success look like? Because we want to frame our approach around what the client feels like success looks like. Because if we win the case and that's not their goal, money is not the outcome that they're looking for, or there's an outcome that we're not able to achieve, then, we're never going to make that client happy. The process is not going to be successful.
Yeah, and I imagine they'd be less likely or less, not that any client is happy about paying your legal fee, your legal bills, but they'd be even less so if you're running up court costs in litigation and that isn't even the outcome that they want. I imagine that they're going to have a lot more resistance to paying that monthly invoice. So there's a practical side to that as well.
Talk about another anxiety producing situation.
Absolutely. So it occurs to me that a theme that has been consistent throughout our conversation today has been about how important it is to listen to your client and really hear what it is that they're telling you. And in that way, we are a counselor in addition to a lawyer. So one last question, I guess, are there some takeaways or key takeaways that you'd like to share, final thoughts before we close out today?
Yeah, I think exactly what you just said, like allowing our clients to feel heard, I think is the number one tool that allows us to put on that counselor hat and, view our clients' problems from a lot of different vantage points, which allows us to be a better counselor. I think the second point is it's not so much all about the client's well-being, it's also about being an attorney and our well-being and being able to deal with the stress and anxiety of this job. And I think, as we discussed earlier, the practice areas are very important in dealing with the mental aspects of this. Also, being able to walk away and put down a case and come back to it with a fresh viewpoint is super important. And lastly, we talked a little bit about mediation. I personally think, and I know a lot of attorneys agree, that this is a great tool to deal with client anxiety and stressors throughout litigation by putting our client in a more informal environment and allowing them, like you said, to be heard throughout the process. And that informal environment where they can state their piece and, talk directly to a neutral third party and explain their side of the story, I think is very valuable and avoids a lot of the stress, the anxiety, the cost of litigation that are really the big stressors for our clients.
Yeah, excellent. Thank you so much for sharing your expertise and thoughts and ideas this morning and for inviting me to engage in the conversation with you. It's been great. It's been a lot of fun. Thank you to all the listeners for listening to Brief Encounters.
Thank you.
This episode of Brief Encounters was brought to you in part by our sponsor, LawPay. Schedule a demo at lawpay.com/DCBar to see why LawPay is trusted by 50,000 law firms.